Good afternoon, everybody. My name is Karen Nadoff.
And I'm Alan Press, and we're partners at Shire Law Group right here in Lincolnshire, Illinois.
We're thrilled to have you joining us this afternoon for Your Life, Your Way, Family Estate Planning. We encourage questions throughout the course of the presentation, so please feel free, as Ashley mentioned, to just drop them into the Q&A or the chat. And if we don't get to your question right away, it's most likely because we are going to be covering it during the course of the presentation. And at the end of the presentation, if you have any questions for us at that point, we're going to stick around to make sure we get all of your questions answered. If at a later time you want to contact us, we encourage you to do so. We really love getting questions, and you can give us a call at 847-955-9000. Or you can email us, and it's Karen, C-A-R-E-N, at shirelawgroup.com, or Alan, A-L-A-N, at shirelawgroup.com.
And as Ashley pointed out, we can't hear or see you, but when you put questions into the chat or the Q&A, they can remain anonymous. I think if you just direct them to the panelists, and then, we're not going to use your name unless you want us to, but we'll go ahead and repeat the question and then answer it for everybody. So with that, I think we're ready to get started, right, Karen?
Absolutely.
All right.
Hey, many of you joining us this afternoon, you come from all kinds of different backgrounds. Some of you have backgrounds in business, careers in the medical field. Some of you may work from home, raising children, or possibly have your own home business or started a business. You all have varying hobbies and varying passions. And you put aside money for education, some of you for your home, some of you for travel. But no matter where your life has taken you, and despite these differing professions and hobbies and passions, there are some things that we all share in common. And that is a vision of how we want our hard-earned money to be spent and distributed, and how we want meaningful objects to be preserved and appreciated. For example, in my family, we have a vase that has been passed down through many, many generations, and that comes with a very important story that's germane to our particular family. We want to make sure that that vase continues to get passed down and that story continues. Another important thing that we all have in common is wanting to protect ourselves and our family. So there's a way to empower yourself by coordinating that vision of how we want our hard-earned money to be spent and distributed, and how we want meaningful objects to be preserved and appreciated, along with the goal of protecting ourselves and our loved ones. And the way to do that is with an estate plan. So your family is your priority, and having an estate plan allows you to plan for your family's well-being. An estate plan allows you to achieve peace of mind, to plan your best future, and to protect the ones you love. You plan every day. Every day we plan what time we're going to wake up in the morning, who we're going to contact that afternoon, who we're going to connect with. One of the most important plans that you will ever make is planning for your estate plan. So what is estate planning? We're going to cover the basics this afternoon. Estate planning is the process of using an attorney to help you prepare for your future by planning who you want your wealth, your assets, your property, and more to be gifted to after you pass away. And those people that you gift to are known as your beneficiaries. Estate planning also involves for planning how you want your wealth, your assets, your property, and more to be gifted to after you pass away. Estate planning, an important piece of estate planning, is directing your health care and guiding your finances during lifetime. And we're going to spend some time on that this afternoon. Also, estate planning involves minimizing or avoiding taxes and minimizing or avoiding probate, which can be time consuming and expensive. And we're going to talk about probate as well this afternoon. Documents that are part of an estate plan that we'll be discussing this afternoon are a last will and testament. We're going to talk about trusts. We're going to touch on different types of trusts. And we're going to discuss powers of attorney and healthcare directives.
So we're going to start off with talking about what is a last will and testament. And this is probably the most common document that we're all familiar with. It's commonly referred to simply as a will. A couple things to know about a will. A will is only going to be effective at death. That'll be an important point to remember when we contrast this to a trust. But remember that a will is only effective at death. It allows you, typically someone might have a will, like I would have a will that says when I pass away, I want all my assets to go to my spouse. However, if she predeceases me, then I want my assets instead to go to my children. That's a pretty common setup for a simple will. A will would also allow me to designate a guardian or guardians for any minor children. And it also instructs the probate court of who you want to receive what. So a document like that is going to allow you to put in the document that when you pass away, you want certain things to happen. You want certain people to receive assets or money, and those things will be delineated within the will. So what is probate? Probate is the legal process of administering an estate of a deceased person to both resolve all claims and to distribute the decedent's estate. It's a clearinghouse for a deceased person's assets and liabilities. So it is a court proceeding, and when somebody passes away, a probate may be required. And we're going to talk a little bit about that today as to when a probate may or may not be required. A probate handles an estate. And what's an estate? An estate is a legal entity that's created at your death to handle all of your bank accounts, your home, your car, and any other assets that you may own in your own name, as well as handling any obligations or liabilities that you leave at the time of your death. So what are the objectives of probate? Well, there's several. One would be to inventory all assets. So when there's a probate, there has to be an organization and things have to be figured out, like what assets are out there. So they're typically an inventory would be completed. Some of those assets may need to be appraised. That could be for tax purposes. That could be for distribution purposes. If you have a will that says, when I die, I want my house to be sold and the proceeds to be divided equally among my children, it's going to be important to know what that house is worth or what it should sell for. Payment of creditors. This is also very important because let's say I die and I owe a creditor $50,000. How is that creditor supposed to get paid? And the creditor might also be concerned that if all of my assets consisted of a $100,000 bank account, that creditor probably wants to make sure that they get their $50,000 before my beneficiaries get the money, get the balance of the money in my estate. Probate could be used to resolve disputes. That's very common. To change the title of assets. So when I die, I own assets in my name. Those assets have to go to the beneficiary. So there has to be a way, kind of like a clearinghouse, to pave the way for those assets to be distributed and retitled into the name of the beneficiaries. And distribution of one's estate is also an obvious goal of completing a probate. How does probate work? When somebody passes away, it's the responsibility of the person who's named in that person's will as the executor to open the estate. If somebody passes away and they have no will, then any interested person can step up and ask the court to be appointed as the administrator of the estate. And there's actually a statute that says who has priority and preference in getting that appointment or choosing that person, but that would operate pursuant to that statute. So how probate gets started, like we said, an interested person is going to file the will with the county with the probate court in the county in which the person resided. So the will gets filed with the county, whether or not a probate is going to be needed. That actually is a requirement in Illinois. You're supposed to file the will with the county within 30 days of the person's death. And then the county is going to safeguard that will. And if a probate case is needed and opened, then the will is already in the possession of the court, so that case can be opened easily. If needed, a probate case is opened by the filing of a petition. If there's no objection to the petition, the court is going to appoint the person named in the will as the executor to have the authority to administer the estate. Notice of probate is going to be sent to all of the heirs and all of the known creditors. Notice also needs to be published in the newspaper in case there's any unknown creditors. There has to be a public notice that goes out in newspapers to alert creditors that somebody has passed away. This enables them to make a claim in the probate court. And then the executor or the administrator may also need to purchase a bond or have a surety on a bond. So this would be like a little insurance policy that, protects the beneficiaries of an estate in case the executor or the administrator is going to do something wrong or lose some of the money. This is very expensive, this surety on the bond. So one of the benefits of doing a will is that you can actually excuse that requirement and wind up saving the estate a lot of money just by having a will in place that excuses the surety on the bond. So what are the responsibilities of an executor or an administrator? Well, their job is to gather, inventory, and safeguard all estate assets. If necessary, they may need to sell certain assets or liquidate certain things so they can make payouts to the beneficiaries. They could use estate assets to pay any valid claims, such as funeral expenses, legal fees and costs, executor fees, and any legitimate creditor claims would need to be handled as well. They also need to publish notice of the probate in the newspaper so unknown creditors would be aware that somebody has passed away. Any known creditors, they actually have to send actual notice to them. So that would be in the form of a letter saying, hey, Mr. X has passed away and we believe that you're a creditor. So if you have, a claim to make against his or her estate, you need to file a claim by, such and such a date. And also handling taxes. So that might involve getting a tax identification number from the IRS. And so the estate itself could have its own tax identification number. So a lot of work involved there. So how long is probate? Well, we know it's not going to be any shorter than 6 months because the publication requirement is a 6-month period in order to allow creditors to make a claim after the notice is published. So we know it's going to be at least 6 months. It typically, though, can be a lot longer. If there are no issues and things are moving pretty smoothly, typically a year or so is what a probate's going to take. If there is a conflict or a dispute, or if there are any complex issues to handle, it could be much longer. So what are the things that would extend the length of probate? Well, if somebody makes a claim that the person who created the will, the deceased person, was unduly influenced, like they had a gun to their head when they were signed their will, or if they didn't have the mental capacity to make the will. Those are things that need to be litigated in the probate court. So that could extend the period of time. If someone is claiming that the execution of the will is improper, the signing and the witnessing. Illinois, like most states, has very strict requirements as to how a will needs to be signed and witnessed and whether or not it needs to be notarized. So there are rules about all of those things, and someone can make an argument that a will is not valid because it wasn't executed properly. There may be confusing language in the will. We try to be very careful when we're drafting wills and documents, but sometimes people draft wills on their own and they may not be quite as clear in their intent, and that could be a problem. So then you have to ask the court to interpret, to try to figure out what was the intent of the person that passed away. What did they mean by this language? And then also creditors' claims, they may need to be litigated. Just because, a creditor might come in and say that the person who died owed them $50,000, that may or may not be true or accurate. So the estate has the ability to say, well, we don't agree with that. And that might have to go to litigation. So that can also extend the time period of probate. Accusations of wrongdoing by the executor, if there are any complex tax issues that need to be handled, that could extend probate. What happens too if there's trouble locating or identifying heirs or people that are named in the will? Hopefully there's not a will that's filed that says, I hereby leave all my assets to a common name like John Doe, and there really isn't any other identifying information. Who did the person mean? Or you may not know anyone in the family is entitled to notice of probate. It may be difficult to identify who those family members are. Families could be spread apart. The information may not be readily available to the executor or to the administrator. So that's something that could extend probate as well. And let alone like what happens if somebody has like a child outside of wedlock or a secret family or something like that. You just never know what's out there. So that could take some time. There also may be an inability to liquidate certain assets like real estate. It may be hard to sell a house. Maybe the house is in bad shape, it needs repairs, and it's difficult to find a buyer. That could extend probate as well. So when is probate necessary? There's a common misconception that if you have a will, you avoid probate. That's not true. If you have a will, it may make probate much simpler, more efficient, and less time consuming, but you still may need the probate. Probate's going to be necessary when there are assets in the name of the person that passed away, in their name alone, that in the aggregate are going to exceed $100,000. However, certain assets don't count. So if you own something jointly, and we can go to the next slide because that's going to show that a little bit better. So when probate is not necessary, well, first, any assets that are held in a trust avoid probate, and we'll talk about that in a few minutes. Any assets that are owned in joint tenancy. So if I own an account with my daughter and I pass away and we're joint owners of that bank account, that doesn't have to go through probate. In fact, it's not even governed by the will. By operation of law, my daughter, who is the co-owner of the account with me, becomes the automatic sole owner at the time of my death. So that's an important thing to remember. Also, anything that's subject to a beneficiary designation. So if I have an IRA or a life insurance policy that names my son as the beneficiary when I die, that's a contract that I have with the life insurance company or the custodian of the retirement plan. So I have a contract with them that says when I die, that they should pay the proceeds of that policy or account directly to my son. So it doesn't matter what my will says, that is going to take precedence over anything that's in the will document. Also, anything that's subject to a transfer on death or payable on death designation. So if I have a bank account and it's payable on death to Karen, well, Karen is going to get that account when I pass away. Again, it doesn't matter what my will says because that designation takes precedence over what is contained in the will. So when is probate not necessary? Some additional examples would be if we're below that $100,000 mark. So in my example, if everything I own is one bank account that has $90,000 in it, that's below $100,000. So that wouldn't have to go to probate. If I had a will, the will would still need to be filed with the court, by the way. But you could use what's called a small estate affidavit or a sworn statement in order to get the bank to release those funds to the people that they're supposed to go to. So that's a detailed affidavit, but that would avoid the probate process. However, if I have two bank accounts and one of them is $60,000 and the other is $70,000, well, each account is below 100, but together that's $130,000, which puts us over the $100,000 mark. So in that situation, a probate would be required in order to release those funds. So let's switch gears for a second to trusts. And that was one of the things that avoids probate. There's a common misconception that trusts are only for the very wealthy. That is simply not true. A trust can be used for people in many different socioeconomic levels, and it would be beneficial for many people. And we're going to talk a little bit about that this afternoon here. So first, what is a trust? So a trust is a legal document like a will. It's something that you draw up and you sign, and it's created by you, the grantor, during your lifetime. And in essence, what it's going to do is streamline the administration of the assets that are placed in the trust during lifetime and after death. So this is where that distinction between a will is important. As you may recall, the will is only effective at death. A trust is effective immediately upon signing and also after death. So trust is something that can span both life and death. A trust does avoid probate. We saw that in a prior slide. So therefore, it's a private document. There's no public record. Probate is a public proceeding. So if my neighbor passes away and there's a probate estate, I can go down to the courthouse and ask the clerk to see the file. And not because I'm a lawyer, but just because I'm a citizen, they would give me the file. I'd be able to look at what's in the estate, to see who's getting what, to see if there's any debts. There's none of that with a trust. A trust is going to remain as a private document. A trust is also going to provide maximum control over your assets and how they're distributed, even after you're deceased. So you can kind of control things, from the grave. So let's say you have beneficiaries that are not good with money. Maybe a beneficiary that has a gambling problem or something like that. You can create terms within your trust to direct your trustee on how to handle that money for the benefit of that person who might have a problem handling it themselves. So you can get very granular in setting up how you want those things to be controlled. A trust is also going to bypass the cost and the time of probate because it avoids probate, and it's going to enable you to carry out your trustee to carry out the wishes exactly as you set them forth in the trust document. So let's take a look at a couple of trust terms. I've been using a couple of these, so let's figure out what I was talking about. The person who creates the trust can be called the settlor or the grantor or the trustor or the trust maker. All of those terms are interchangeable. We like using the term grantor at our law firm. It's just the easiest in our opinion, so we use that term, but that's the person who creates the trust. The trustee is the person who's going to control the trust. They hold the assets in the trust, and they have to follow the instructions that the grantor created in the trust document when they're managing the trust. Can the trustee be the same person as the grantor? Well, the answer is yes. In fact, that's quite common, especially in what's typically known as a living trust. I may create a trust for myself, but during my lifetime, I want to maintain control over the assets in the trust. So I'm the trustee and I'm also the grantor. The third term is the beneficiary. The beneficiary is the person who's going to receive the benefit from the trust. So they're typically entitled to the income and the principal in the trust document. Can the beneficiary be the same person as the trustee and also the grantor? And again, the answer is yes. I may create the trust. I'm going to make myself the trustee during my lifetime, and I'm also going to make myself the beneficiary while I'm alive. Now, if I become incapacitated, the trustee may change to a successor trustee that I've named in the document. And when I die, the beneficiaries will probably change within the document. It'll probably say that after my death, I want my trust to be distributed as follows. So the beneficiaries can change during your lifetime and after death, and as well as the trustee can change as well, because if I can't act anymore because I'm incapacitated or deceased, a successor trustee is going to take over for me to carry out my wishes as I set them forth in the trust document. So a couple things to remember about trusts. Trusts are going to give you control as to how your assets are distributed. It's very important that trusts are funded so that they work. We have situations, unfortunately, where people come in after people pass away and someone may have a trust, but nobody ever put any assets in the trust. So it kind of defeats the purpose of spending the time and money of setting that up if you're not going to put assets in the trust. So you want to make sure trusts are funded. This is done by changing the title of those assets to the name of the trust, or designating the trust as a beneficiary of, let's say like a life insurance policy, or naming it as a contingent beneficiary. Trusts avoid probate, which is a great feature of a trust. So it speeds things up because there's no court involvement. There's no judge managing the distribution of those assets. Everything can operate privately. Trusts are private. That's another big feature of these. So if you like to keep your family business private, a trust might be a good way to go, as opposed to doing or relying only on a will. And trusts are very easy to administrate because they don't have probate requirements or court involvement. They provide for immediate transfer of control. So if I have a trust and I've named my son as my successor trustee. Upon my death or incapacity, let's say death, all he would have to do is produce a death certificate, and then he would be able to immediately act to handle those trust assets in accordance with the terms of the document that I set up. So there's two basic types of trust: a living trust, also known as a revocable living trust, or an inter vivos or during lifetime trust. All of those mean the same thing, and that's primarily the trust that we're talking about today. But you could also have irrevocable trusts, and these are used typically for special purposes. So for tax planning or for planning for long-term care, that may be a reason to use an irrevocable trust. Revocable trust, you would use one to plan for disability, because unlike a will, which is only effective at death, a trust is going to be effective immediately. So if I'm in an accident and I get hit by a bus, but I'm not dead, I'm just laying in a hospital bed in a coma, my will isn't going to do anything. But a trust would be effective upon signing, so the trust could be set up to handle any period of incapacity. A trust is going to avoid probate. We've talked about that already. And the trust is going to keep things private, during your lifetime and even after death. The trusts are revocable in the sense that I can make changes anytime that I want to, as long as I'm alive and well. So if my son makes me angry and I want to leave more money to my daughter, I can do an amendment to my trust and change the percentages, and direct more money to go to a preferred beneficiary, or I can change my beneficiaries. If I no longer want to leave assets to a particular beneficiary, I can change who I'm leaving my things to at any time. That right only rests with me, the grantor of the trust, but during my lifetime, I retain the right to make changes whenever I want to. I can remove beneficiaries, designate new ones, and modify any stipulations as to how I want and when I want those assets to be distributed or used for my beneficiaries. An irrevocable trust, again, used for special purposes. One could be creditor protection, estate tax protection, planning for long-term care. That's sometimes a common use of an irrevocable trust. If you want to qualify for Medicaid, you can only have up to $2,000 to qualify. So if you have assets in excess of that amount, one strategy might be to create an irrevocable trust and move the assets into the irrevocable trust. So you're giving up ownership. That is subject to a 5-year look back, though, for Medicaid purposes. So, that means Medicaid could reject your application or assess a penalty against you if you transfer your assets into a trust within 5 years of having to apply for it. That's a whole other area. If you have any questions on that, you can certainly let us know and we can answer them for you. And similar to a revocable trust, it's going to maintain your privacy and is going to allow you to distribute assets in the way that you wish at the time of your death. So we'll just revisit for a moment the importance of funding a trust. Again, this is extremely important. If you create a trust, you want to make sure that you actually put your assets into it so it's going to work. Otherwise, we do have backups for that. So the plan will work overall, but it would have to go through a will to get to the trust. So that's something that you're trying to avoid. You're trying to avoid probate. So funding a trust is going to make sure that everything is going to work properly and you're getting the most benefit out of that type of setup. If you have an unfunded trust, that just means that you don't have any assets in it at the time of your death. We do a backup will that pours into the trust. So ultimately, your assets will go where you want them to go, but they may have to go through a probate first before they get there. And again, that's something that you want to avoid. So you can see there's a lot of moving parts in all of this, a lot of things to consider, joint property, beneficiary designations. The key here is making sure that all of this is coordinated. Drafting the documents is not too difficult. We've been doing that for 25 years. We've got that down pretty well. The art here is in putting all of this together so your assets are going to work with the documents that you're creating. You want to make sure that you understand that beneficiary designations are going to take priority over any disposition that you have listed in your will or trust. So if I have my son as my beneficiary in my life insurance, it doesn't matter what my will or trust says, that money is going to go to my son. If I have joint property, that's going to take precedence again over a will or trust. It's going to go to the joint owner or owners at the time of your death. And remember that your will or trust may say one thing, but your beneficiary designations or your account titling may say something different. So it's very important to coordinate all of this so there are no surprises. And, at the time of your death or disability, things are going to happen the way that you expect them to happen. So with that, I'm going to turn it over to Karen, who's going to take us through planning for disability and talk about all of the great things listed here on this slide.
So many people think that estate planning is all about planning for what happens after you pass away. But planning for disability is a very important piece of estate planning. What happens if you become incapacitated? You need to plan for this. As Alan mentioned, one way of planning for incapacity is through a revocable living trust. That's one way to plan for incapacity. Other important pieces of an estate plan, which allows you to plan for incapacity, involves a power of attorney for property, a healthcare power of attorney, HIPAA authorization, a declaration for mental health treatment, a living will declaration, and a DNR, or a do not resuscitate. And we're going to take each one of these documents one by one. You'll notice that there's an asterisk by some of these documents: the healthcare power of attorney, the HIPAA authorization, the declaration for mental health treatment, that living will declaration, and the DNR, the do not resuscitate. So these are health-related medical documents which make up what is known as your advance directives. First, we're going to look at this power of attorney for property. It's also known as a financial power of attorney or a durable power of attorney. And at Shire Law Group, we call ours a power of attorney for property. Different names for the same type of document. A power of attorney for property is a written document in which you give someone who's known as your agent the power to make decisions on your behalf about your property or finances if you become unable to make these decisions yourself. So even though it's called a power of attorney for property, it involves property and finances. And the thing that's kind of interesting about a power of attorney for property is it can be utilized for incapacity, but it can also be utilized for convenience. So if you are married and you name your agent to be your spouse and you are traveling out of the country and something goes wrong with your bank account and you want to figure out what's going on, because you have a power of attorney for property in place and you've named your spouse, he can then go into the bank and he can sort that out on your behalf. So it's kind of a nice feature. If you word it correctly, your power of attorney for property can also cover that convenience as well as incapacity. Now, in these power of attorneys, only one agent can be named at a time in Illinois. So you can't have co-agents in Illinois. So you name people in the order that you would like them to act because there's only one decision maker. Doesn't necessarily mean that your agents can't collaborate and talk amongst each other, but ultimately there is going to be one decision maker, and that will be in the order that you name your agents. The statutory Illinois power of attorney for property lists the following things that your agent can do for you. They can handle transactions involving real estate, financial institutions, stock and bonds, tangible personal property, safe deposit boxes, insurance and annuity, also handle retirement plan transactions, transactions related to Social Security, employment, and military service benefits that involve tax matters, claims and litigation, commodity and option transactions, business operations, borrowing transactions, estate transactions, and all other property powers and transactions. So if one of these you do not want in your power of attorney for property, you can cross them out. But what we always advise our clients is not to cross out anything, because maybe you're not trading commodities today, but maybe in the future you will. And by crossing that out, you've eliminated your agent's ability to handle that type of transaction. In Illinois, if specific powers are not listed in the power of attorney for property, your agents might not be able to act upon them. So when we do these powers of attorney for property for our clients, we add many, many additional powers because we know from practicing, those powers may become relevant for your agent. Hopefully your agent never needs to use these powers, but if they would need to, it's extremely important that you have them in your power of attorney for property already. And those additional powers that we add for our clients involve gifting, funding a trust, importantly, long-term care planning, very important, US mail, dealing with retirement plans, access to a safety deposit box, insurance, dealing with credit card companies, and there are many more additional powers that we put into our powers of attorney for property. There are actually pages and pages of them to make sure that you're protected and your agent has the ability to act on those powers should they be necessary. We're going to switch over from finances to healthcare. So first we're going to look at is the healthcare power of attorney. This is also known as a medical power of attorney or a healthcare proxy. Again, at Shire Law Group, we use healthcare power of attorney. These are different names for the same document. The healthcare power of attorney is a written document in which you give someone the power to make decisions about your healthcare on your behalf if you become unable to make or communicate these decisions yourself. The healthcare power of attorney does not supersede your right to make your own healthcare decisions. As long as you can make them, you're going to make those. But for some reason, if you were unable to make your healthcare decisions, this healthcare power of attorney becomes essential, where you list your agents to be able to step in on your behalf and make those decisions for you when you cannot make them on your own. Similar to the power of attorney for property, only one agent can be listed at a time, and you're going to list them in the order that you would want them, one decision maker. These are the following powers that your agent has to act on your behalf that are listed in the Illinois statute. So this is what you'll find in there. Your agent can decide to accept, withdraw, or decline treatment for any physical or mental condition, including any type of life and death decisions. They can agree to admit you or discharge you from any hospital, home, or other institution, including a mental health facility. They can have complete access to your medical and mental health records and share them with others as needed, including after you pass away. They can carry out plans that you've already made, or if you have not done so, make decisions about your body or remains, including organ, tissue, or whole body donation, autopsy, cremation, and burial. Now, if you've already carried out plans, your agents that you've listed in your power of attorney for healthcare have a fiduciary duty to make sure those are seen through. Again, there are additional powers that we advocate adding to these powers of attorney. And for healthcare, it's the additional opportunity for your agents, if necessary, to hire care managers and companions. These are super popular, and it's great to have your agents be enabled to hire a care manager or a companion if they think that it would be helpful. Also, patient advocates. This is something that's super, super popular right now, especially because now you cannot sometimes accompany a loved one into a hospital or an emergency room. A patient advocate is someone on the inside who's able to get information outside to you. But we believe, regardless of what the current landscape looks right now, in the future, it's always important that your agents have the ability to hire a patient advocate if that would be something that would be helpful for you. We also add the power of maintaining you in your residence. So that would be your preference. If it's reasonable, you want to be at home. And like we said, we add many more additional powers. The HIPAA authorization goes hand in hand with that power of attorney for healthcare. HIPAA is the Health Insurance Portability and Accountability Act. It's a written document that allows healthcare providers to release and share medical information with people you designate to receive this information on your behalf. So it is very likely that you've all authorized HIPAA before. If you go to your doctor, you sign a form that says that doctor is able to release information to people that are named, maybe a significant other or spouse. The HIPAA authorization that we are talking about putting in place is a general HIPAA authorization. So going back to my previous example, if your spouse is listed on your HIPAA authorization as being allowed to receive your health protected information, and you are traveling and you end up in an emergency room, your spouse would be able to send the HIPAA authorization to that emergency room and find out what is going on. Without this HIPAA authorization in place, the hospital would not have authorization to release your protected health information. And this becomes extremely important. I actually have a personal example of this with my son who was at university and ended up in an emergency room there. And I could not get any information, even whether he was admitted or not, without sending the HIPAA authorization directly to the emergency room to get that information. So the HIPAA authorization is very important. Whoever you name in your power of attorney for healthcare, you want to name your HIPAA authorization, because the people who are making decisions under your power of attorney for healthcare have to get the information they need under the HIPAA authorization to make those decisions. HIPAA authorization looks like this. It says, with your HIPAA authorization, you authorize the release of your protected medical information, including medical reports and records concerning your medical history, condition, diagnosis, testing, prognosis, treatment, billing information, and identity of healthcare providers, whether past, present, or future, as well as any other information that is in any way related to your healthcare to your authorized recipients. The authorized recipients are the people that you're going to name in your HIPAA authorization to be able to receive your protected health information. Unlike your powers of attorney, you can name as many people as you want, and they all hold the same stature. So anybody who's named there all has equal right to receive your protected health information because you've named them as authorized recipients. The living will declaration is often misunderstood. Some people get it confused with a last will and testament or a will, which Alan discussed this afternoon, which dictates the way that your assets will be distributed and utilized following your death. The living will declaration is a legal document which states your wishes regarding life support in the event you are in a persistent vegetative state or irreversible coma and you cannot communicate your wishes. In Illinois, you have the option of having a living will declaration as part of your estate plan. It's not required. A lot of people like to have a living will declaration. Often hospitals may ask if you have one. We can show you the important piece of the living will declaration. You see that up on the screen now. This is the middle paragraph of the living will declaration. And if you agree with it, you could certainly put a living will declaration in place as part of your estate plan. It says, if at any time I should have an incurable and irreversible injury, disease, or illness judged to be a terminal condition by my attending physician, who has personally examined me and has determined that my death is imminent, except for death-delaying procedures, I direct that such procedures, which would only prolong the dying process, be withheld or withdrawn, and that I be permitted to die naturally, with only the administration of medication, sustenance, or the performance of any medical procedure deemed necessary by my attending physician to provide me with comfort care. If you agree with that, you could go ahead and put a living will declaration in place as part of your estate plan. There's also in Illinois the opportunity to include a declaration for mental health treatment. And this declaration allows you to choose whether you would want to receive electroconvulsive treatment or ECT or psychotropic medicine when you have a mental illness and you are unable to make decisions for yourself. You can write your wishes and or choose someone to make your mental health decisions for you on this declaration for mental health treatment. And then there's the DNR. This is do not resuscitate, and this is often misunderstood as well. This must be signed by your physician. It is a medical document or order which tells first responders or doctors not to restart your heart or breathing. Normally, when first responders arrive at a scene or a doctor may give CPR when you stop breathing or your heart stops, you do not want to put a DNR in place if you would want a first responder or a doctor to restart your heart or breathing. So a DNR might be appropriate for somebody who is at the end stage of a terminal disease, or somebody who perhaps has had multiple heart attacks, and if they have one more, they just do not want to be resuscitated. We really like to bring this information about this medical ID app to all our attendees at presentations. We think it's a really valuable tool that many people do not know about, and it's easily accessible. If you have an iPhone, you will see this icon on your home screen. It's a white box and it has a red heart in it. This is the medical ID app. If you have a different kind of smartphone, no problem. You can download a very similar app to the medical ID app, which serves the same purpose. So the medical ID app allows first responders to bypass the lock screen, whether it's a numerical code or a facial recognition, and get directly into whatever information you have placed into your medical ID app. This is especially useful if you have some kind of condition that a first responder would need to know about. And also extremely helpful if there's some kind of allergy that you might have to a medication or to a food. So again, a really useful app, especially if you have some kind of condition that would be known, would be helpful to a first responder or a medical technician. And again, very easy to download if you don't have the iPhone that has this on the home screen. So once you have all your documents together, once you have your estate planning documents together, it's time for a roadmap to be put in place. And oftentimes people don't think of this as part of your estate planning, but we believe this is a really critical piece of estate planning. A roadmap is an informal letter or document which guides your family in understanding and executing your plan and ensuring that your wishes are carried out. And this is a great way to personalize your wishes, identify important contacts, and list assets and liabilities, and much more. So when we do these estate plans for our clients, we always put everything in a nice binder, and it has different tabs, and we have a tab for the roadmap as well. And this gives our clients an opportunity to put in important contacts with emails and phone numbers and addresses, and importantly, passwords to computers where you might have to pay things online. So extremely important to have a roadmap for many different reasons as part of your estate planning documents. The ideal family estate plan, we've been talking about this afternoon, might include a last will and testament or will, or perhaps a living trust with a pour-over will is more conducive for your family. Those power of attorneys for property, the power of attorney for healthcare, authorizing individuals to step in on your behalf if you can't make medical decisions for yourself. HIPAA authorization, authorizing people to receive your medical protected information. That declaration for a living will, if you agree with that middle paragraph that we put up on the screen. Assignments and deeds, beneficiary designations. As Alan said, coordinating your plan is really the art in all this. So we're going to make sure that not only is your plan funded if you have a trust, but your beneficiary designations are also aligned. Long-term care planning, extremely important. Possible irrevocable trusts, if that is something that would be advisable. And a roadmap of your estate plan. So having an estate plan that reflects you and your family's unique values and goals brings you peace of mind. Governor Pritzker, during the course of this pandemic, has authorized remote signatures, and that makes it easy to put in an estate plan remotely. So everything can be done online. When we do these for our clients, we throw everything up on the screen, they review everything, and we make sure that we keep on going back and forth until it's absolutely perfect. So that's a really nice benefit. So you don't need to wait to put your estate plan in place. If you don't have one, you're considering it, something that you should do. The other thing that we wanted to mention is we had gotten a question earlier from somebody who wanted to send a question ahead of time, and that was about powers of attorney for young adults. Once your children turn 18, they are considered legal adults. And with that designation comes some important changes for you and for them and for your family as a whole. One of those changes is that your access to their financial and their medical affairs becomes limited without proper documentations in place. And this takes us back to the power of attorney for property, the power of attorney for healthcare, the healthcare power of attorney, and the HIPAA authorization. So very important that if you have an 18-year-old, those things are put in place. So if for some reason they couldn't make their own medical decisions, you could step in on their behalf and make those. If you needed information about them that you couldn't directly speak with them and they were in a hospital or an ER room, through the HIPAA authorization, you could get information, and that you could act on their behalf for financial affairs through that power of attorney for property. So we'd love to get any questions you might have. We love getting questions. You can drop them right into the chat or the question and answer.
And we'll just clarify that with the remote signing of documents like this, the executive order does provide that the signing can be done through two-way audio video communication. There are lots of requirements, like it needs to be recorded, and there's other requirements, and we take care of all of that, but we do send the paper documents to the client, so they are signing, you're signing actual paper. We're not yet allowed to use actual signing online or using some sort of DocuSign or something like that. So that's not available yet in Illinois, but hopefully we're getting there soon.
Hi, I have a question really quick for you guys. Is there a I guess a best practice as far as updating these sort of documents? I mean,
Well, the nice thing
life is long.
Yeah, the nice thing is that the documents, we make them very flexible. So let's say you create the documents and then you have another child, or you have a grandchild. The documents are designed that you wouldn't have to tinker with them every time there's a life change. Now, if there's a major life change like a divorce or something, that may require you to make changes. But other than that, the documents are designed to grow with you. But that having been said, we like to meet up with our clients every 3 to 5 years to review things and make sure that everything still makes sense. So that's part of what we discuss with our clients, is making sure that they're keeping in touch with us, we're keeping in touch with them. If there's any changes to the law, or if there are any changes on the client side that might necessitate a change or an update to the documents. The good news is, though, that they're pretty easy to update. And so that makes it easier for people to do.
There was a question in the chat about if this would be, I'm going to share this. We are recording and it will live on the library's YouTube for a while, I think we decided. So I will send this out to everybody that's registered, and you'll be able to share it with whomever you think should have access to it. I have another question about, oh goodness, what was my question? It had to do with, oh, dang it. Now I've forgotten, sorry.
That's okay. If you or anyone else, has thinks of a question after the session, our emails are there up on the screen. That's one way to contact us, or just giving us a call. Or, we're happy to answer any questions that people have. It's an important topic, and one that you definitely want to make sure that you've got everything in line and you're all set up to protect yourself and your family. So
I remember it. So what is your recommendation or thoughts around like communicating your ideas with your family? What your plan is with your family?
Yeah, that's a great question. And that is a common question. So it's a good one. So oftentimes, depending on the family dynamic, maybe if you have, for example, a trust in place, you don't want to really talk to your children about what's in the trust. You want to keep that private, but you do want them to be aware that you have these powers of attorney in place and they might be listed. So one way you can do that is just to say to them, we've put this in place. This is where the binder is, or however you have your estate plan contained. For us, it's through our binder. Or you can electronically send just those powers of attorney. So when we do these for our clients, we have the binder that has the copies and the originals, but we also do electronic copies. So like, for instance, with my son who was in that emergency room, I sent the electronic copy right out. So in a crisis, in an emergency, those electronic copies, especially with those powers of attorney and the HIPAA authorization, going to become very important. So if you feel comfortable sharing those powers of attorney and the HIPAA authorization, you could share them with those that are listed, or if not, just tell them that you have done estate planning and this is where my estate planning binder is, or wherever you keep those documents.
And that answer is going to be different for families at different times, right? So depending on comfort level and what your relationship is with the people that you've named in the documents, you may decide, now maybe to hold off and showing it to them, but as you get older and then you may change your mind about that. So it's kind of a fluid situation. There's no right or wrong answer to that. It looks like there's a question too about, does a trustee need to be within the United States, or can we name someone residing in a different country? As long as the assets are in the United States, I don't think there's any prohibition against having somebody foreign, but you might want to consider, maybe making them a co-trustee and having a domestic-based trustee. That might work a little bit easier. I know today everything is online and we have easy access no matter where we're located in the world. So it's a little bit less of an issue. Again, I'm not aware of any specific prohibition against that, but just my gut is telling me that it may be a good idea to have them maybe co-trustee with a domestic-based person as well, or a trust company. And if there's nothing else, we'll probably come to an end. Go ahead, Ashley. I'm sorry, I didn't mean to step on
Yeah, no, that's great. Yeah. Like I mentioned before, we'll post this on the library's YouTube. And, I run into folks when life was normal, we used to see each other at events. So, the Shire Law Group is, a community partner. So I very much encourage people to reach out to you directly, and that you're just such easy people to talk to and work with. So we're always happy to host you, and thank you for your time today.
Thank you. It's been a pleasure being able to speak with you all this afternoon. Thank you, and have a good day and happy holidays to everybody.
Bye.
Thank you, everybody.